inviting me to share my views on the topic. However, being aware, my perspective, my thinking as to how the law applies in the court of law before the judges, with respect to the facts that we present, somewhat differs from the learned friends, teachers who have presented their view. So I will not go because certain changes no doubt have been made. But the fact of the matter is this, all these changes are cosmetic, superficial. Fundamentally, the Indian Evidence Act still subsists and we have to understand it. My respected principals and the teachers and certain friends have expressed their view. So, being in the legal profession, from this perspective, from this angle, I would like to actually say something about this Indian Evidence Act. Once I was also a student like you. No doubt, anyone who complete the LLB, certainly, and they should aspire to become the judicial officer in the first place. And in Bihar, particularly, I find that whatsoever be the reason, I will not go behind the reason. But still, I hope that my learned teachers and the students, there will be proper cooperation so that at least we can give as many as possible the judicial officers. But being a judicial officer, as I perceive and as I think, we need to know everything with great precision. Whatsoever we know, but we know it with great precision. For example, I say in the Indian Evidence Act, the term relevant has been used. What is the relevant? How many of you understand what is the term relevant actually signifying? When two facts connect each other in such a manner that one fact throws light upon the other fact, then it becomes relevant. So we have to understand deeply. Suppose that we take the term like proof, and if we understand the term like proof with the term like evidence, then it gives us a new idea. Because when we say proof, then it is actually understood that whatsoever be material before the court, having produced the material before the court, if the court thinks that this particular fact exists, then it will be deemed that that fact exists. Or it may be in the particular facts and circumstances, anyone can suppose that that fact exists, then it will be said that it is proof. So the evidence now has been defined, oral evidence and documentary evidence. But the term proof, you see, only the matter has been said, has been actually referred to. So going beyond the oral evidence and documentary evidence, whatsoever material comes before the court, having viewed the scene, appreciated the scene, actually the court thinks that particular things have been proved. So you people have to study the law very in a very precise manner. You cannot actually, if you people really things to crack the examination like Bihar judiciary or other judiciary, then you have to understand this. Because no doubt certain changes in the new evidence act have been brought about because it was necessary. Why it was necessary? Because certain, you see, provisions were there that have become obsolete. Obsolete means they were not in use for a long time. So why they will become the part of our evidence act? That is why they have been implemented. Secondly, with the passage of time, what has happened that certain needs were added. That is why something has been also incorporated in the new law, particularly digital electronic evidences that has become the part of our system, because we all carry mobile. Because I have come across many of the cases in which the only ground of conviction was the photograph or the video that was captured in the mobile. As a lawyer, I face this kind of situation in the court of law. And I want you people to simply understand the law in a very proper manner and deeply. Suppose that you have been asked anything, that very my learned friends have also referred to that section. Suppose that section 24, inducement, promise, coercion, neutral person has been added. If the confession is affected by any one of them, it becomes irrelevant under section 22 of the Old Act. And now you have to also see along with that section 27, that is very relevant. 27 says that suppose that any material has been discovered by the police in consequence of the information given by the accused person who is in the custody of police, all these conditions must be satisfied. Only then section 27 will be attracted. Then the facts which distinctly relates to the information given by the accused person, then only such part of the information will become relevant. It will be admitted in the court of law. There are many case laws on this. I will not go and case laws are there. Doman Upachaya or etc. So you people have to understand the law in a very, very deeply understand. Otherwise, answers, because I sometimes come across sometimes the answers written by the estimates. So while writing answer, you don't have to beat about the bush. You have to be very miser in utilizing your words. Suppose that the answer says that you have to write the answer in 200 words. You don't have to cross this 200. Otherwise, the more word you will write, the less the number you will achieve and secure. You have to be very precise. I think my students are not perhaps enjoying but it is necessary that you people study hard, and teachers are very brilliant, and I hope that many of you in years to come will become judicial officer. And with this I hope and I give my blessings to all that you people also rise like a hero, become a hero in the society. And yes, but you people have a very strong competitive feelings. Competition, the feeling of competition should be very keen. That somebody, if you ask any question in the field of law, you all think that I will defeat him. This is the attitude with which you have to study. Only then you compete all across India, because the students of Bihar goes to UP and the students of UP come to the Bihar, and you have to competition with the students who are coming from the UP, coming from the particularly Delhi, and you see the standards of learning and standards of knowledge that they are having. So I want you people to have the cutting edge of the competition, that you have to compare with them. And I don't see, because I also belong to this particular this town. So I hope that my students all not suddenly excel in this field of law. And law is not very difficult, but law requires also, like other subjects, high level of concentration, high level of understanding. If you are playing with the law simply casually, law will not help you build your career. I simply say you this. If you want to build a good career in the field of law, 2 or 3 things must keep in mind. Be serious towards law. Be serious towards the language in which you are going to express your law. Either Hindi or English does not matter at all. चाहे आप हिंदी में लिखें या अंग्रेजी में लिखें, कोई फर्क नहीं पड़ता है। भाषा पर पकड़ होनी चाहिए। आपके पास कम्युनिकेशन स्किल बहुत बढ़िया होनी चाहिए। बिना कम्युनिकेशन स्किल का आप निश्चित रूप से अच्छा लॉ में नहीं कर सकते हैं। फिर आपको लॉ के सारे प्रोविजंस के सारे अलग अलग अंगों का भी पूरा अंडरस्टैंडिंग होनी चाहिए। और बार बार अपने उत्तर को इस प्रकार लिखिए कि उसमें पूरा प्रोसीजर आ जाए, और लिखने के बाद अंत में अपने हर उत्तर को 2 या 3 महत्वपूर्ण जो लीडिंग केसेस है उससे उसका समर्थन कीजिए। आपको निश्चित रूप से एवं 65-70% नंबर आएंगे एंड योर पीपल विल सक्सीड इन योर लाइफ। विद दिस ब्लेसिंग्स आई एंड माय स्पीच।